Good morning, everyone. I'm Ann Koontz. I'm here with my partners, Marina Parkin and Jackie Durham. Today's February 9th, and we're coming to you to talk about Homestead. It's February. It's the time to be talking about filing your Homestead exemption, whether you've purchased property during the last year or you are going to be moving into a property that you'd already purchased to make it your homestead. So we wanted to kind of go over some of the differences, some of the common myths, things that we hear people say that are not correct, and answer any questions that you might have. So if you do have questions, please use the Q&A box at the bottom of the screen. We'll get you squared away and get your questions answered. And also, as always, our webinars are recorded and distributed on our YouTube pages and our KoontzAssociates.com and KoontzParkin.com websites, and on our Facebook pages. So without further ado, I will, what you got, Jack?
Well, I guess we could start by just distinguishing between the homestead tax exemption and the homestead creditor protection, because they sound to be the same thing. And some folks think that if they establish their homestead tax exemption, that they've automatically established or filed for their homestead tax exemption, that they automatically are entitled to the homestead creditor protection. And that's not necessarily the case. It's one step that's in the right direction, of course, but you want to make sure that you're hitting certain markers in terms of this actually being your primary residence. And there's a whole list of factors that Joanne and I will share with clients who are moving to Florida and trying to establish a homestead. So just to kind of distinguish between the two, the homestead tax exemption is something you can claim up to $50,000 of an exemption against your assessed taxes. So just to kind of give you an idea, there's the just value of your home, which is the fair market value, the assessed value, which is your basically the just value less any limitations on the taxes that can be imposed against your home due to caps that the state offers. If it's non-homestead, it's 10%. If it's homestead, it's 3%. And then you have your taxable value, which is the assessed value less the $50,000 homestead exemption. So it's important to keep those different terms in mind, because they get kind of thrown around and people get confused. So I just wanted to start by clarifying that. So if you claim your homestead tax exemption, you can get up to $50,000 deducted from your assessed value of your home. The homestead creditor protection, on the other hand, is something that protects your primary residence, your principal residence, if you reside in Florida, from creditors. And it's the best creditor protection out there. A lot of folks want to put their properties in LLCs, and we often have to explain that the homestead protection is actually an even stronger protection. So it's a very valuable protection, but it can only apply to your primary residence being in Florida. So we just kind of want to fish that out and make sure everybody's clear on the difference. Just because you have a tax exemption under homestead does not necessarily mean you have the homestead creditor protection, and vice versa. So just want to clarify those differences. Joanne, do you have anything to add there before we kind of go into exactly how the exemption works?
No, I'll save my war stories for a more appropriate time.
All right, perfect.
Just when we get to problems.
Right. So I guess the way it typically begins is you purchase a home. You intend for it to be your primary residence or the primary residence of someone who can be claimed as a dependent of yours. Either of those circumstances work for purposes of claiming the homestead tax exemption. And you basically, after the purchase, as long as you are residing in the property as of January 1st, you by March 1st can claim that property to be your homestead for tax purposes. And following that, you'll receive a $50,000, up to a $50,000 tax exemption, assuming your property is $75,000 or more. So that's a very helpful tax exemption that comes on top of the tax limitations that the state offers. So by March 1st, you have to file that DR 501 You have to confirm and establish your residency, which there's a number of ways that you can do that. And the state can always come back and ask for more evidence that you've actually established residency. So things like voter registration, your driver's license, abandoning your voter registration or driver's license in your former state of residency, things like that, pay stubs, things like that can be used to establish that residency. Now, what also comes with the homestead tax exemption, thankfully, is the Saver Homes cap, which requires that following the year you make that homestead tax election, that the assessed value of your home cannot increase more than 3% year over year. And that's a huge benefit, because if it's a non-homestead property, that cap is 10%. So this is actually a pretty big savings, which a lot of people enjoy taking advantage of.
And to be honest with you, is more impactful than even the $50,000 off the assessed value, because depending on your millage rate, that $50,000 off is about $600. I mean, it's not inconsequential amount of money, but when you talk about how the savings can be, the difference between the 10 and 3%, depending on where the value goes, that number is huge, and it compounds over time.
Right, exactly. And just real quick, once you gain that homestead exemption and the Save Our Homes cap benefit, you can lose it. So it's not something that you can just hold on to forever, and there's no stipulations to that. So there are a couple ways that I just want to mention that a lot of people are unaware of, especially in this day and age with Airbnbs and people renting out their rooms or their guest houses or things like that. Some folks can get into trouble because there are certain limitations. Number one, you can't rent the property for more than 30 days for any 2 consecutive years, or during any year for 6 months or more. So if you do any one of those things, you're going to be deemed to have abandoned that homestead. So you need to be cognizant of what you're doing with your property. Also, if it's no longer your primary residence, obviously you can't claim it as your homestead any longer, and you will be deemed to have abandoned that at the time that you essentially took on a different primary residence. And also certain changes of ownership. If you transfer legal or equitable title in any number of ways, that will be deemed to have abandoned the homestead. Now, there are certain exceptions for transfers between spouses, where there's no change in beneficial ownership interest, or if there's a transfer upon death. I'm not saying all of those circumstances insulate you from this. I'm just saying certain circumstances that fall into those categories, you may be exempt from that restriction. So just want to say that out loud, because a lot of folks are not aware of these things, and it can be a surprise. And something else that is a surprise to people is if you abandon your homestead in any number of ways, when it changes from a homestead property to a non-homestead property, there is automatically going to be a reassessment of your just value. So that doesn't just happen when you sell the property. It happens when there is a shift from a non-homestead property to a homestead property, and vice versa. And a lot of folks are surprised by that. I had one client who was, for whatever reason, did not originally claim the homestead tax exemption, and then 10 years later realized, oh, I should claim this because of the Save Our Homes cap and also because of the $50,000 exemption. But when they went to do it, they learned, hey, the just value of my home has gone up a lot in the last 10 years. And the reassessment that I'm otherwise going to realize or incur as a result of claiming the homestead exemption may outweigh the benefits of the homestead exemption, because this person may ultimately be selling their home in the next few years. So it may not always make sense financially, but you have to kind of weigh that and see, on a case-by-case basis if it makes sense for you. But just be prepared for that the change of the tax designation will trigger a reassessment of the property taxes. Anything to add in here, Joanne or Marina, yet?
When people are making those changes, a lot of times because they've married, or because they've divorced, or trusts, or people decide they go to a seminar or hear a webinar and decide they need an LLC, before you make any changes, you need to speak to someone to be sure that the vesting you're going to have after your transfer will still be eligible for homestead, because there are certain types of trusts that are not eligible. No LLC, even if it really is your primary residence, if it simply by being titled to an LLC, you'll be disqualified from having the homestead exemption on the property. So there are some things that can cause a problem that you may not realize. So before you make any changes or do anything, you should consult with a lawyer.
Absolutely. And that also goes to who actually, like Joanne was saying, who actually qualifies to make this tax election. And I should have mentioned that earlier. It's supposed to be a natural person. Now everybody's like, oh, well, what about my revocable living trust? Yes, those typically are considered to be an alter ego of the individual, so they therefore typically qualify for that homestead exemption. However, I will say that, like Joanne mentioned, it's really on a case-by-case basis. There's actually other trusts that can qualify as well. Less than a year ago, Bill McCollum issued a written opinion about land trusts. And there's also even certain irrevocable trusts. But it's really on a case-by-case basis, and you have to satisfy certain criteria. And it really is a conversation that needs to be had between you, your real estate attorney, and your trust attorney.
Yeah.
It needs to involve everyone, especially when it comes to estate planning. So I would mention that, and I will also say that there's a lot of spookiness around even the revocable trusts, because there was a bankruptcy judge that deemed a revocable trust not to be qualified to make qualified for the homestead creditor protection. And what happened is they ultimately had to subject that property to sale, even though they thought that their property was protected by that homestead creditor protection. Now, certain Florida judges and certain circuits have ruled against that and have not followed that opinion. But there's a lot of uncertainty sort of surrounding that. So what a lot of practitioners also say is, if you are in a high risk profession, such as a doctor or such as a building contractor, you know, it may make sense from an estate planning standpoint to put a property in a trust, but for purposes of creditor protection, keeping it outside of the trust and holding it with your wife as tenants by the entirety, or that's ultimately going to be probably your best bet if you're in one of those high risk professions. But that's, again, on a case-by-case basis. I just wanted to mention that because these are questions I get on a pretty regular basis, and a lot of people got really spooked by that bankruptcy opinion. So sorry, Marina, I think you're going to say something.
No, I'm glad you brought up the rental piece, because that's the part for me on the tax side that I get quite a bit. People always ask, well, what's the tax implication of, you know, if I want to rent out my house a certain number of days a year, if we're out of town or whatever the case may be. The other popular tax strategy, which a lot of my clients use, is actually having their business rent their house for under 14 days to use it for a meeting or conference or whatnot, and be able to deduct that as a rental expense on the business side. So these are all great strategies, but I think that when you're keeping all of that tax in mind, you can forget that you can jeopardize your homestead. So if in the example of, let's say you have a business owner who's going to use that strategy of 14-day a year rental for the business, and then let's say they have a few more weeks when they want to rent it out on Airbnb, they've already crossed that number of days that's allowed without realizing it, because it was little pieces at a time, but they added up pretty quick. So I think that's extremely important. And I will also be mindful too to chat with people if I see that that's something they are interested in doing, to make sure that they're not messing up on the homestead side.
Awesome.
Joanne is rolling her eyes. The war stories are coming.
Yeah.
Right.
Yeah. This is like legal WebMD. Like this is when people start telling you what prescription they need, and it seldom is the right prescription or the right dosage.
Well, I guess what we could touch on next is one of the other benefits of the homestead exemption, which is the portability. So if you have previously claimed a homestead exemption, you're actually able to typically port those homestead benefits, that Save Our Homes CAT benefit, into the next homestead that you purchase. So you do have to make a particular election to make sure you're claiming your new homestead and you're claiming the right to maneuver that portability into the new homestead. And you do have a finite amount of time. It actually changed under statute recently. It used to be like 2 years, and now it's 3 years from January 1st of the year in which you sold your property, not the actual date of the sale. So if you sold your property and say your homestead in October of 2020, that is going to begin to toll. The deadline to actually roll over your homestead Save Our Homes cap is going to begin to toll January 1st of 2020, not October of 2020. So just keep that in mind, that you do have a finite amount of time to do that. But basically the way that portability works is, let's say the difference between your just value of your original homestead and your assessed value was $100,000, and you buy up and you buy a more expensive homestead. You can take that $100,000 credit essentially and roll it over into the new homestead, and that will reduce your just value and help you reach your new assessed value in the new homestead. So that can be really beneficial. It's calculated a little bit differently if you're buying down. So if your original homestead was, you know, 800,000 and you buy another homestead after that for 600,000, they actually, the portability is based on a percentage basis, not on a dollar basis. And it's also important to note that portability is capped at 500,000. So you won't ever be able to port anything more than 500,000, but it's a really nice feature, especially for those who have already been claiming a homestead. And this is also going to apply even if you're shifting your homestead. So let's say you have a second home, and now your new homestead is going to be the beach house, and your old homestead was somewhere else. Even if you swap these, you can still port that cap, which is really nice. So.
Yeah, and the other thing I want to mention too is, if your previous homestead was out of state, you are going to have to prove to the state of Florida that you've rescinded or revoked that homestead from the prior state. So you may just need a letter from the county on their letterhead saying that's been revoked, if they can't see it, like if it hasn't processed already where they can see it online.
Right. Right. So that's in a nutshell, I think enough to get everyone, enough knowledge to be dangerous. But it really, I didn't want to dive into too much detail because I feel like it can really vary on a case-by-case basis what people can really do with their homesteads, and especially from the homestead creditor protection standpoint, a lot of these questions get crossed. And so I just think, again, it's really important before you make any kind of change to title or beneficial ownership interest in your property, or shifting your primary residence, anything like that, you really want to talk to your attorney to make sure that you know what you're signing up for, and that you properly make the new homestead election, you properly make the portability election, and take advantage of these, these tax benefits, because they can be really helpful. And like I said, I've had clients that didn't know any better to claim the homestead, and they kind of missed out on some tax savings as a result. And sometimes it doesn't make sense to then change it to homestead later. So important to talk to your attorney when you purchase or when you're going to sell.
Now, is it war story time?
I think so.
So one situation that I think just happened with a client of ours in the last 6 months that was very interesting is when you talk about blending families. So I had a client who got a notice from the property appraiser who said, hey, your homestead is improperly claimed since 7 years ago. He's like, what do you mean? I've lived in this house for 22 years. Well, he got married and his wife moved from Indiana, and they put her name on the quitclaim deed, and that's, they did a quitclaim deed to add the wife. She was constitutionally, because it was homestead, already an owner, but she wasn't on the title. So the county would have never picked up on it if they hadn't recorded the quitclaim deed, but they did record a quitclaim deed, and they went, hey, this lady has homestead in Indiana. Lady moved here, moved out of the house, never even thought, because of course up north, homestead's not nearly as big of a tax savings as it is here. So they hadn't even contemplated removing and revoking her homestead off of her Indiana property, which she kept and her adult kids were living in. So when they recorded the quitclaim deed, they said, hey, how long? Oh, 2013. Great. Here's the bill for what you owe us for improperly claimed homestead for 7 years. And guess what they had to do? Pay. There is no way around that. There is no letter, there's no application, there's no I'm sorry, there's no backdating your revocation with your old state. So these things happen in 100 different ways, but that was a huge one. And we were talking north of $50,000 on this house, and it was a modestly priced home. So these things get big quick. We do have a question. We just moved here. If we haven't sold our other house in Pennsylvania, will Pennsylvania let us switch our homestead to Florida? All you have to do is contact the county that your home is in Pennsylvania, and ask them what their procedure is to revoke the homestead, and get written confirmation of that to provide with your homestead application to your county in Florida. So that's pretty easy.
Staying with the same theme, Joanne, talk to me about two spouses claiming two homes in two different states.
I'll live in New York and he'll live in Florida.
Exactly.
If everyone else has thought of it, they've already legislated around it. So if you came up with your tax strategy at a cocktail party, you don't actually have a tax strategy. Unless you're at the cocktail party with Marina. Again, you can have multiple, what we do see lots of times are multiple owners, maybe partners or families, maybe parents and kids, who go and buy a house together, and somebody's going to live here full time and somebody is going to visit. To the extent that you've got people in the house full time, they would be able to claim homestead and they would get half. So if I live here and my husband doesn't, then we're going to get a 50% deduction, $25,000 off the tax assessed value of the property. The big problem comes in when it comes to the constitutional protection, because of course the people who still live up north have a car accident. Well, they own property in Florida that's not homestead. So now, you can get into some messy situations with attachment of judgment liens and creditor liens for that property, to the extent that it is not homestead for the parties who are also owners. That's messy, messy, messy. We see that come up the most when we have kids, and I use air quotes because they're maybe young adult kids who the parents are on the title to the house because they're lending their credit to get institutional bank financing for the kids to buy the house. That sometimes is unavoidable, but we really need to have a think about that, because again, everybody's driving a car. There's other ways that liability can come up, and it diminishes their homestead protection. It's a menagerie of problems, and it is a domino effect. Sometimes it's unavoidable because this is the only way somebody may qualify for credit. Sometimes it's just lenders wanting a stronger application, and you might still, maybe mom and dad can give a little bit more money down so that the kids can qualify on their own without adding them to title and without them being co-borrowers. There's a lot of different ways to approach that as well. So what other, any other questions that you feel like you get a lot, Jackie, that are common misconceptions or where people maybe have the rules wrong?
Well, you just mentioned the one about the parents buying the property for their kid, and it's important to note that you can qualify for homestead even if it's just one of your legal dependents occupying the property as their permanent residence, but they have to be a legal dependent. Mm-hmm. So a lot of people say, oh yeah, no, because my kid is legally dependent on me. They're at college, so we bought them this house. Again, they're talking to their buddy at a cocktail party, and their friend's like, oh, well, my overgrown son needs a house. I want to buy it for him. He's not my legal dependent, but he does need my help, and I want to buy him a property. That's not the same thing. So it's just another fine distinction that I think can get people. And like Joanne mentioned, the assessments can add up really fast. And what you have to keep in mind is there's not only assessments, but there's interest and penalties, and that's where they really nail you. So it's really important to, again, talk to your attorney before you do anything like this, just to make sure you're planning things properly and you don't spend a lot of money to structure something that is ultimately going to gain you a higher bill in 10 years.
Yeah, absolutely. Yeah, and then penalties for improperly claiming homestead. And where they're really coming down on that is there are literally folks being paid to comb the Airbnb and VRBO listings. So if you think you're going to sneak that up there and I'm going to keep homestead, but I'm going to rent it while I'm stuck in New York and can't get back down to my house, you know, they easily find that. It takes time. They don't find it right away, which is why people get brazen and continue to do it. But it's very, very, it's like speeding. Like, you don't get caught every time you speed, but when you do, it's like, just give me the ticket. I was speeding.
Right.
Now, let's talk about the time frame for the application for homestead. So keep in mind that you have to, January 1st is the drop dead date for everything with respect to your real estate taxes in Florida. So that is the assessment date. In theory, every single property in the entire state of Florida is assessed on January 1st. Now, of course, the property appraiser is not working on January 1st, and it takes them a good 8 months to get those assessments together. So then the property appraiser creates the trim notice or the proposed tax assessment. You receive that in August. That's when you have an opportunity to complain if you're not happy about your tax value. And then you get your final bill late October, early November. That bill that comes in November is for January 1st through December 31st of that year. If you buy in January 2nd to December 31st, you get whatever homestead election your seller had on January 1st. So if you bought from someone that was homesteaded this year, your 2021 tax bill that will not come till the end of 21 will have the homestead exemption from your seller. If your seller did not have it homesteaded and you go ahead to homestead, it will not be effective until 22. So the reason we're here today is because the deadline to file is March 1st. However, if you just closed on your property in January, you have until March 1st, 2022 to file your homestead application, not 21, because you're stuck with whatever your seller had. So keep that in mind. And we've got a question here that says, we will apply for homestead as soon as possible, but what does it mean for deducting last year's mortgage interest payments for the Florida house for when for the last year, Pennsylvania was our homestead? Marina, can you talk about how that looks on the tax return for deducting which becomes your primary residence on the Schedule A?
So really, the way that we would kind of be careful on the timing. Mm-hmm. And I think the key here also is to say, you know, how do we file the Pennsylvania tax return? Mm-hmm. So when people move out of Pennsylvania to Florida, it's important to, from any state for that matter, it's important to file a part year resident return in that state. So we would say, okay, they were residents in Pennsylvania from January 1st to, let's say, September 1st. Do you have a date there in your question, Joanne? No, okay. Mm-hmm. And then we say, so that basically, once that's filed with Pennsylvania, Pennsylvania knows not to expect a tax return anymore going forward in future years. So it's important in the year of the move to file a part year resident. Mm-hmm. And to be honest with you, for all the multiple states that we've done, I've never seen one that didn't have that option. So pretty much all of them have that part year resident option mm-hmm. in the state. So then when you get to Schedule A, which is your itemized deductions for mortgage interest property taxes, then you would essentially you know, for the part of the year that property was your principal residence and the amount of property tax that you paid, you put both of them. So let's say you paid X amount on your property in Pennsylvania, and then you bought property in Florida, and this much of the property tax is prorated. So you would make sure the prorations are there and then include both the amounts on Schedule A as the itemized deduction. So also keep in mind, though, that you are going to be limited to $10,000 on property tax, combined property tax for all of the properties. If you are converting, let's say you're keeping your Pennsylvania home and you're converting it to rental, then you would prorate the property tax and say, okay, if up to September 1st, it was my principal residence, you claim January to September prorated portion of property tax on Schedule A, which is your personal itemized deduction. And then from October 1st to December 31st, that becomes your rental expense. So that does not go into the itemized deduction, that goes on the rental schedule, and the rental schedule property tax does not have a $10,000 limitation. Does that make sense? Make sense to everybody? Okay.
I got my my nugget
You
out,
got
of the webinar.
It's not partnership basis, but it's pretty good good plan B there, Jackie.
There's no shortage of dumb tax questions on my end, so I love learning this stuff.
Oh, mercy, mercy, mercy. Well, I think that the big thing here to take away is to be mindful that there is a distinction between the constitutional homestead protection and the tax protection, to be mindful of the calendar and the deadlines, because that is something that people just don't appreciate in terms of, they see March 1st coming and they're like, oh my gosh, I just closed. And then they're calling like, hey, my deed's not recorded yet. Well, you just closed 3 days ago. It has to be recorded for the property appraiser to accept it. They won't accept the copy that we give you at closing. They want to see one that's been indexed and recorded in the public records. So keep in mind too, that it is the date of the closing. So for people who close at the end of December, even if your deed doesn't get recorded by the county, maybe it's sitting in a pile because of the holidays and it doesn't actually physically get recorded till January 2nd, if your purchase date was back in December, you're still going to be eligible in the prior year. So they don't run by the recording date, they run by the closing date for eligibility for homestead for that year. So another distinction I want to point out is when you do your application, if you do your application for homestead online, that application will automatically ask you for your prior residence, whether it's out of state or in Florida. And if it's in Florida, it will automatically do portability for you. You don't have to take any extra steps. However, if you go in person, you are required to file a separate form for portability than you are for the homestead application. So I especially like to advise our realtor clients to say, because people ask the realtor all the time, what do I do for homestead? We cover it at the table, but not every place does. And of course it's weeks after. First, they're worried about getting moved in and getting their utilities and their internet set up. So they're not really listening always at the closing table to that, because it's like, I don't need to know it today. I need to know the garage code, you know, more practical, urgent matters. So when it is time to go do that, if you do have maybe clients that are elderly who maybe aren't super tech savvy, if Marina Parkin is your client, she may not want to do it online.
I will not.
Or if you just enjoy local government offices and you want to have a stroll down, you can get a face first full of it. They are, of course, by appointment now. In non-COVID times, you could just stroll in there and wait your turn.
Right, but that paper application, you're right. If you're not doing it online, there is a separate, it's a homestead assessment difference form that you do have to file to get that portability benefit. So just make sure if you're doing it paper-wise or going in person that you're filing both of those, and they both have to be filed by March 1st. So you have to elect that portability at the same time that you're electing the initial homestead.
I've got a good question here. Now, I've got a realtor who's saying, hey, it'd be great if the title company could just file the homestead information for the buyer. I can't. And the reason I can't is I've got to upload their driver's license with their new address. I've got to upload a utility bill or a voter's registration card. You can't apply until they have established their residency and the utility bill and the voter's registration card evidence that. Plus the deed's got to be recorded. So it's not something that we can take away from the table and run off and do for them. They've got to do it several weeks down the road. So that's why you don't see title companies doing it, because it would be too cumbersome. By the time they got all the information and emailed it to me, they could just upload it to the website. It's not, you know, anybody's unwillingness to be helpful, but more of a practical consideration. But I get asked by buyers a lot at the table, like, are you going to do this for me? you got to do homestead, and you're going to have to, and you're going to have to do your HOA applications. Like sometimes there's barcodes for gates or clickers or things like that for access in some of the gated communities. And that stuff we just can't physically do because we don't have the information just yet. So any other questions?
I do have a question.
Okay.
Talk to me a little bit about foreigners, non-residents, citizens, non-citizens. There's a slew of different situations that I see on the tax side, and I tell you, I guess, where I'm coming from with this question. You can be a tax resident of US without being a citizen.
Correct.
And that depends on, that is evidenced by then how you choose to file your income tax return. So you may live here full year, or at least most of the year. You may have a job, you may have a business here. You're considered tax resident. You may or may not have citizenship. You may or may not have a green card. You may have different types of visas. What are your choices on homestead?
So only US citizens can have homestead, because if you have a green card, you are allowed to remain here, but you are still a resident alien, meaning you still belong at home. You're just allowed to be here as much as you want. So it can only be your homestead if it's your primary residence. It can't be your primary residence if you're supposed to go home at some point. So E2 visa holders, L1 visa holders, green card holders, not eligible for homestead in Florida. May be eligible for some primary residence deductions on the tax return from an income tax standpoint, but the IRS code is different than the Florida homestead code. So that doesn't, I get an email, I would say twice a year, from a green card holder who says, hey, what is your crazy state doing? They denied my homestead application. You're just not eligible. So that's why
if you have one of the spouses that is and one of the spouses that is not, does that matter?
They would get half. Just like if you and I owned property and I was living there. Yeah.
They do not get both.
No, they're not on the MP plan of get both. No, they only get one. So they would get $25,000 off of the tax assessed value every year.
Okay.
Now, Michael says, if my closing is March 2021 and I'm stuck with seller status through 21, and I have until March 1st, 22 to apply for Florida homestead, is it to my advantage, and can I postpone revocation of my prior homestead in another state until late 21? Until late 21, yes, but you've got to have it revoked by December, because the whole application that you're going to be signing by March 1st of 22 is going to say that on January 1st of 22, this was my primary residence, I was occupying it as my primary residence, and I didn't have another homestead elsewhere. So no later than December 31st, you would have to revoke in the prior state. There are some northern states that do taxes on a quarterly basis rather than annual. We are unusual in Florida that our taxes are in arrears. So when you pay in November of 21, you're paying for back to January 1st. Most places are prospective, not retrospective. The New Yorkers are always like, really, you pay taxes late? This is crazy. That would not happen up north. So, so just be mindful of that as well. The calendar is very strange with how these things work. Your trim notice doesn't come till August. You have 25 days from the date of the notice to complain about it. If you miss the bus, you're out until next year. If you forgot to claim homestead, you're out until the next year. You can't go back and do it. So you can file anytime. I tell people, if you do close in March of 21 and you don't have to file until March of 22, you can still get your application in unless you're trying to hang on to, to a prior homestead up north. The thing is about that though is making sure that you've got that calendared so that you don't mess that up, because we definitely have the strongest homestead protection of any state in the country. So I had the unfortunate circumstance to live in Ohio for more years than anyone should be subjected to when you're not in prison. And their homestead exemption was only up to $60,000 of equity, the first $60,000 of value of the property, which doesn't go far even in Ohio where things are almost free. So down here, that dollar amount of savings is big quick. So you don't want to, step over dollars to pick up dimes and miss out. So,
well, just ask OJ.
Just ask OJ. You can, however, you have to be here, but you can also be in prison. And that leads to probably my final misconception is people think they mix up the 183 days test for foreigners to be subjected to U.S. income tax and say, well, I'd love to be a Florida resident, but I'm not going to make the 183 days. There is no 183 days. Florida doesn't care. We don't have a state income tax. We're not trying to keep you out. It needs to be your main residence. So you could live in Florida for 3 months. You could live in Aspen, Colorado for 3 months. You could live in Italy for 3 months, and you could live in New York for 3 months. Florida can still be your primary residence, even if you don't hit that 183 days. But it's your main home where you intend your primary residence to be. There's other factors that go into that, like Jackie said, that are beyond the scope of today. But and if anybody wants that residency test list, we can certainly send it. It's more income tax based. It's really not related to homestead. We created that list in anticipation of a large dollar value income tax audit from a state, from a retiring person who is getting a sizable package that we wanted to protect from state income tax. So, and we avoided that audit, and it was great. And now we have this lengthy list of insanity that I love to pass out. So
well, and it's important to remember too that as much as you want to do all of that in Florida and meet all these factors and also go through the homestead, you really do need to be careful of what's happening with the other state, because it's the other state that is taxing you that is going to be chasing you. So I think all of these laws, even I would imagine the homestead laws are going to be a little different in every state. So you want to be sure to check with them to make sure if you've established Florida homestead, that you want to make sure that everything is clean off from where you moved from to cut that.
Absolutely. Absolutely. Also, the other place that we see people trying to do some switching around of ownership is when parents start to get elderly, and you need to be careful too, because you may be upending mom's long-standing homestead when you title that property to your name because you think you're dodging the nursing home. So again, it may be still something you want to do, but you just don't want to have any unintended consequences, and then you get smacked with a huge tax bill because your homestead exemption has been revoked that's been on the property since 1964. So that Save Our Homes cap is pretty sizable, and you don't want to blow that up. So I think that's all from me. If you guys have any other thoughts, I'm happy to field them, and if not, we'll let people get back to their day.
Yeah, no, I have nothing further to add.
Nothing further.
That was plenty.
That was plenty.
You've scared people enough.
It's my job. I don't know what else I would do if I didn't do this. So
for once, I'm not the one scaring people.
Well, speaking of scaring people, if you tune in next Tuesday, Jackie will be presenting part 2 of how asset purchases can go sideways in the contract if you're not careful. So if part 1 wasn't enough, watch out, because part 2 is coming. And if you are interested in part 2 and you don't recall part 1, you can also go back to our website or to our YouTube page and check that out as well. So thank you so much, everybody. I hope you have a great week. We'll see you next week.